Well, good morning, everybody. Nice bright day. I don't know how many like me watched the Aurora Northern Lights last night. Aurora Borealis is probably the best way of saying it. But they were bright over Ranton, so I don't know what it says about Stafford, but I know there's some pictures at Doxey. And white over with frost this morning, so we're getting several different weather patterns all at once, and a solar one as well. On to the business. Could we start, please, with apologies?
Yes, thank you, Chair. I've received apologies from Councillor Jill Waring and Councillor David Williams. Thank you.
Thank you. And the minutes of the meeting on the 23rd of September. Are we happy with them?
Yes, happy with that.
Okay. Right, and it does say David Smith's in attendance. Yeah. Sorry? It was the site visit. Okay. Happy for me to sign them? Yes. Okay. Thank you very much. And we'll move on to a verbal report on the S53 delegated decisions. This is something that David's asked for in the past. Have we got anything to say about it?
No, none to report, Chair. It's just a verbal update, and at the moment there's none.
Okay, thank you. But we'll leave it on the agenda, please. Thank you. And item number 5, which is the Wildlife and Countryside Act 1981 application to modify the particulars contained in the definitive map and statement, which require modification in relation to public footpath 89 Biddulph Town. Hannah, are you taking this one?
Yes,
Okay, and then afterwards, I understand the local member wants to say a word about it as well. Thank you.
of course. Okay, thank you, Member Chair. So in this case, public footpath 89 Biddulph is currently on the definitive map as a cul-de-sac route. So public footpath 89 connects to Grange Road to the west, and it stops south just of Mill Cottage, which is situated northeast of the footpath. But footpath 89 Biddulph does not connect to another highway to the east. The applicant in this matter has identified that there is an anomaly with the definitive map and statement in relation to public footpath 89 Biddulph, and that the termination point of the route depicted on the map does not match up with the description of the termination point in the statement. The statement states that public footpath 89 finishes at road about 150 yards northwest of Elmhurst, which would be Hurst Road, but this is not how the route is depicted on the map. Evidence has been submitted from the time of the first draft definitive map, which came about as a result of the 1949 Act, which shows that a parish survey map was produced showing the line of public footpath 89 Biddulph as it currently is on the definitive map. However, a further line has been added onto the parish survey map in green, connecting from the eastern end of public footpath 89 and continuing in a northerly direction to connect to Hurst Road. Next to the green line in pencil is written the word add. This green coloured line follows the same line as the applied for route marked A to B to C at Appendix B. The documentation shows that a decision was made that public footpath 89 should connect to a public highway at both ends and therefore should continue to Hurst Road. However, no definitive map has ever shown public footpath 89 continuing along the line of the route marked A to B to C, despite the fact that the statement has always referred to public footpath 89 terminating at road northwest of Elmhurst. No evidence has been found as to why this is the case. An order can be made to modify the particulars in the map and statement where there is conflict between the map and statement, i.e. the description and the depiction of the way do not correspond, as in this case, and this is dealt with under section 53, 3C3 of the Wildlife and Countryside Act. The applicant has applied for an order to be made to modify the particulars in the map and statement for public footpath 89, and specifically for an order to be made to modify the map by continuing the line of existing public footpath 89 along the line of the route marked A to B to C, so the map and statement correspond with each other, based on the evidence in the first draft definitive map. Alternatively, an order could be made to amend the statement to reflect where the current line of public footpath 89 terminates, as opposed to changing the line of public footpath 89 and therefore changing the definitive map. So when we consider the relevant legal tests, in order for an order to be made to modify the particulars of the map and statement for existing public footpath 89, the evidence needs to show on a balance of probabilities that the map and or statement is wrong and one or both needs modifying. The definitive map and definitive statement of public rights of way is a legal record of public rights of way, and therefore it is important that the definitive map and the definitive statement correspond with each other when detailing any public right of way. Therefore, the issue of whether the map and statement should be modified in relation to public footpath 89 does need to be addressed. It is the officer's recommendation that the evidence shows that the map should be modified and an order should be made to continue the line of existing public footpath 89 along the line of the route marked A to B to C to correspond with the statement. However, the panel can determine that an order should be made to modify the statement for public footpath 89 to reflect how public footpath 89 is depicted on the map. Thank you, and I'm happy to take any questions.
Okay, thank you for that. Have we any questions on this? Oh, yeah, apologies, yes. Local member.
Yes, thank you, Chair. I just want to
You're welcome.
Yes, thank you, Chair. I just wanted to just emphasise and bring to the committee the fact that this particular issue on this regularisation of this footpath was brought to the Planning Committee at Biddletown Council on Tuesday the 16th of April 2024, and within your pack you've got a supporting letter, and the recommendation was from the Planning Committee that they do support the officer's recommendation in relationship to regularising route ABC and route BD. In your report pack, paragraph 64, which clearly states on the parish survey card that the path starts opposite the Talbot Hotel, which is something which we did see for those who went on the site visit, and it goes through and exits at the road by the cottages at Elmhurst, which is actually Hurst Road. It begins with a stile through the meadow to a second stile into the road. Obviously that second stile was, according to the report, closed up around about 2015-2016. I'd also like to bring the committee to the attention that there is no representation whatsoever within any either documentation or public submission that that footpath was ever considered before 2015 as a cul-de-sac. Every description had it entering opposite the Talbot and leaving by the road for continuation up the road. Thank you.
Thank you very much for the information. That's really helpful. I think one thing that was discussed at previous meetings and training and such like is that our job is to put the footpath on the definitive map, or say that a footpath is not available for the definitive map. And in this case, where it's been blocked up by a third party, if we put it on the definitive map, it's then the job of the countryside committee, not committee, what would you call them, the department, countryside department, to actually get that opened up again and the style put back in place. That's the position we sort of find ourselves in. Thank you. Paul, did you want to speak?
I'll go with officer's recommendation. I think it's made out, it's the balance of probabilities. It's also supported by the local member and by the local town council. So we're not going against anyone else's request, really. It's historic that it was there. And if it means that the landowner themselves have got to pay to have the style put back in, so be it. It's their responsibility. So I'll propose and we go with officer's recommendation.
Thank you. Any seconders? Carolyn?
Happy to second
Okay,
that.
so
Thank
we've
you.
got a proposer and a seconder to go along with the officer's recommendation. All those in favour? That's unanimous. So thank you, Hannah. And we'll move on to the next. Thank you, Nigel. Right, we have got item number 6 now, which is the Wildlife and Countryside Act 1981, application to upgrade public footpath 16 Alton Parish to a public bridleway. Have we had any representation from the local member on this one?
No, we haven't.
Okay, thank you. And the report's been done by...
That'll be myself.
They don't give you a rest in between.
No, afraid not.
Thank you.
Okay, thank you, Chair, members. So, yes, this is an application to upgrade existing public footpath 16 in the parish of Alton to a public bridleway. The application was submitted by Staffordshire Moorlands Bridleways Group and was submitted based on historical evidence. The original evidence submitted consisted of a 1910 Finance Act map, an Ordnance Survey name book dated 1920, a copy of the National Parks and Access to the Countryside Act 1949 definitive map. The applicant also submitted a document called the History of Alton. So if we turn to the evidence first, the 1910 Finance Act was concerned with mapping lands throughout the UK for the purposes of taxation. In this case, the finance map shows a route running along the same line as the alleged route. The route is shown as 2 solid lines and the route is shown separate from the adjacent land. The route also has the annotation Toot Hill Lane alongside it. The map does show footpaths and they are depicted as a single broken line and with the annotation FP. The alleged route is not depicted in this way. The Finance Act map shows the physical existence of the route, and it is highly suggestive that the route has rights over it higher than a footpath or bridleway. However, there is no evidence as to whether the route is public or private, or the exact nature of the rights over the route. When considering the Ordnance Survey name book, a number of documents were produced in connection with the production of Ordnance Survey maps, and they can be of assistance in providing supporting evidence of the existence and status of some routes. Information on named routes can be found in name books. The Ordnance Survey name book provided refers to the route Toot Hill Lane, and the description given for the route is an old public road extending from north of Rose Cottage, Alton, to a short distance west of Cedar Hill. The document is suggestive of the route being public and having rights over it higher than a footpath. The copy of the National Parks and Access to the Countryside Act 1949 definitive map shows the alleged route with arrows along the route, and this therefore signifies that the alleged route was classified as a RUP, a road used as a public path. The expression RUP was intended to include public carriage or cart roads on metalled lanes that were mainly used as footpaths or bridleways. However, the term RUP was deemed to be unsatisfactory, and therefore, as a result of the 1968 Countryside Act, all RUPs were reclassified as either footpaths, bridleways or byways open to all traffic. The fact that the route is depicted as a RUP is suggestive that the route was capable of being used by vehicles, but it was likely to have been predominantly used as a footpath or bridleway. Officers have also obtained a copy of the parish survey card for Public Footpath 16, which denotes the route also as a RUP. The route is described as being 6 to 8 feet wide, between stone walls and grass covered. The actual status of the route and the nature of any rights over the alleged route is unclear from the parish survey card. The applicant also provided a report that was completed called History of Alton. Under the heading Places and Objects of Interest, it states Toot Hill reached by a bridle path from Town End. The applicant states that this refers to the applied for route. It is not clear that the bridleway referred to in the text is definitely the alleged route. In addition, the purpose of this document is unclear and it is not a legal record of public rights of way. Officers also reviewed further documentation relating to the application route, including an Alton tithe map dated 1843, an Alton and Bradley in the Moors enclosure award dated 1833, and a historical map for the 1900s. Looking at the tithe map, tithe documents are solely concerned with identifying tithable land. The tithe map does show a route running along a similar line to the alleged route. The route is shown separate from the adjacent land as a main highway or carriageway. This would suggest that the route has rights over it higher than a footpath or a bridleway. However, it could be a public or private route. The route is not numbered and therefore not listed in the accompanying award, so there is nothing to indicate the status or nature of any rights over the alleged route. However, it is unlikely that a tithe map will show public footpaths or bridleways, as their effect on the tithe payable was likely to be small. As the route is not numbered and based on the information provided from the map, there is little evidence from the available tithe documentation to assist in describing the nature of any rights over the alleged route, other than it was likely to have rights over it higher than a footpath or bridleway, but these could have been public or private. Turning to the Enclosure Award, enclosure acts were designed to enclose land to increase agricultural productivity. A route is again depicted on the enclosure map running along the same line as the eastern section of the alleged route. The route is depicted as two solid lines and again as a highway or carriageway. The route proceeds in a northerly direction and then curves following a westerly direction, where the route meets a plot of enclosed land and terminates. The route to the west does not connect to another highway. The map states old enclosures in the township of Alton. This would suggest that the plots of land the route connects to are old enclosures as opposed to land being newly enclosed. This would suggest that the route was a pre-existing way. The route is not named and is not depicted in the award. There are a number of other routes shown on the map that are depicted in a similar way to the alleged route. Some of these routes are recorded as public carriage roads and others are recorded as occupation roads. The route is not included in the award and therefore it is not clear what the status of the route is. As the route leads to plots of enclosed land, it may be that the route was considered to be private and was for people accessing the plots of land. However, this is not conclusive from the award. Also, even if it was a private route, it may at a later date have acquired public rights through express or presumed dedication. The historical map for the 1900s shows a route running along the same line as the alleged route, and it is depicted as two solid lines and has the annotation Toot Hill Lane written alongside the route. Footpaths are also shown on the map, and the alleged route is not depicted in the same way as these routes, which is highly suggestive that at the time the map was drawn up, the alleged route was considered to have rights over it higher than a footpath, although there is nothing from the map to indicate the exact nature of any rights over the route. This map again shows the physical existence of the route, but it does not distinguish whether it is public or private or the exact nature of any rights over the route. When considering evidence submitted by landowners, in response to the application, several landowners did respond, with the majority of landowners advising that they considered the route to be a footpath and access track to their properties only. And one landowner stated that they had seen people using the route on foot, horseback and bike. Several of the landowners have raised concerns about safety if the route was to be upgraded. Alton Parish Council also responded to the application, advising that they support it. They have advised that members of the Parish Council are aware of the route being used in the manner of a bridle way. There is anecdotal evidence of use of the route as more than a footpath that has been provided by Alton Parish Council, but there is insufficient evidence to suggest that the route has been used at large by members of the public as more than a footpath over a significant period of time. When considering the relevant legal test to consider is whether on the balance of probabilities, the classification of the route as a public footpath is wrong and therefore the map and statement are wrong. If the evidence is evenly balanced, then the existing classification of the route as a footpath on the definitive map and statement prevails. Overall, the documentary evidence supports the physical existence of the route, which is not in dispute as the route already exists as a public footpath. The documentary evidence overall shows that historically the route has been depicted as a main route as opposed to a minor route. The 1910 Finance Act and tithe map evidence show the route separate from the adjacent land and therefore likely to have rights over it higher than a footpath, although it does not clearly distinguish whether any rights over the route would have been public or private. The parish survey evidence is supportive of the route being capable of being used as a footpath and bridleway, as well as being capable of being used by vehicles, although the exact rights over the route are not clear, and ultimately at the time of the first definitive map, it was determined that the route should be added as a footpath only. Overall, the evidence supports the route having higher rights over it than a footpath, but as the exact nature of the rights are unclear, the route should be upgraded to a public bridleway only, as there is no clear evidence of vehicular rights over the route. In addition, there is no clear evidence that any higher rights that exist over the route were not of a public nature. Therefore, it is officers' opinion that the application should be accepted and an order made to upgrade public footpath 16 Alton to a public bridleway. Thank you, and I'm happy to take any questions.
Thank you for that. This is quite I feel, quite a finely balanced decision we've got to make here. Just one more quick question from me. The parish council, how definitive were they about it being a bridleway or staying as a footpath? I presume they definitely didn't want vehicles on, which I can understand.
So when the parish council responded, they confirmed that they were in support of the application. The application was discussed at a parish council meeting, and the information provided from the parish council was that members of the public and also councillors did provide evidence historically. Some of that evidence dated back ranging from the 1950s through up to approximately the 1970s, that people had used the route either on horseback or there was some anecdotal evidence of motorcycle use, and also one member did put forward evidence that I believe in the 1950s that the route had been used by a milk float delivering milk. So they felt the evidence, along with the historical evidence, supported the application.
Okay, thank you. Caroline wants to speak first, and then Paul.
Thank you, Mr. Chairman. Excuse me, I've got a bit of a cold, so I always get a little bit confused with what it states on the main person who owns the land around here, and we don't get those documents. We do see. I own a drive that 7 other properties are on, and they have rights of way across, just like some of the people are saying here, they've got rights of way across. But it's still my drive. It's not a public drive. So I see why this is so difficult to get to, but I don't understand why we don't get, on my deeds of my house, it states I own that. So it's very clear. We never sort of get anything like that. Someone has to apply to someone to have rights of way across. And that's all in here, but we never seem to get the person who's stating they own this, their legal documents. Could you explain why we don't see those?
In terms of the Section 53 process, it is about discovery of evidence. So sometimes when somebody buys a property, there may not be a public right-of-way recorded as going across their land. However, if somebody then subsequently a member of the public, be that through historical evidence or user evidence, believes that there is a public footpath that does exist but is not recorded on the definitive map, they can then make an application under Section 53 for the public right-of-way to be added to the definitive map. And it's obviously, once that's been investigated, and if that public right-of-way is found to exist, it will then be put onto the definitive map and will be registered with land charges. So would then come up that a public right-of-way existed. The challenge is if somebody buys a property and there is no application pending, there is no right-of-way, then they will naturally assume that there are no public rights of way across their property. Unfortunately, that doesn't stop at a later date somebody making an application and saying, actually, we believe a public right of way does exist and therefore should be recorded. Also, public and private rights can coexist alongside each other. So you can have a track that maybe is classified as a public footpath, but also provides private access rights for properties that adjoin the track to allow them, for example, to use their vehicle to access their property, but a member of the public wouldn't be able to use their vehicle along that track unless they were accessing one of the properties.
Okay, Paul?
I think this one, the old adage, once a highway, always a highway, seems to go. If you go back to the Finance Act, Enclosures Act, Tithes Act, it's 2 roads, or highways running parallel to each other. One is named, one is not named. So to me, it's the case on the balance of probability, if nothing else. I mean, the evidence is quite strong, even taking balance of probabilities out of it, that it does exist. My only question I would ask is, he talked about 6 to 8 foot for when it was a footpath. Are we going to put a minimum on it now of 2 metres or 3 metres so that people, the landowners can't try and narrow it down? If we're going to turn to a bridleway, we're going to put a minimum width on it.
We will look at the historical evidence, and in a case with historical evidence, it would usually be the width of the route provided in the historical evidence that would determine the width that will exist if the route is added to the definitive map.
Well, my proposition that we go with officer's recommendation, I'll propose that.
So Paul's proposing we go with officer's recommendation. Seconded by, do you want to speak or do you want to second it? Seconded by David. And all those in favour? Okay, thank you, Hannah. We're going with your recommendation. We'll move on now, please, to item number 7. Wildlife and Countryside Act 1981, and this is an application to upgrade PF37 Leekfrith Parish to a restricted byway. And Steph, are you taking this? Thank you.
Yes. Good morning, Chair and members. Before I start my commentary to the report, I would like to say a few words about the note for circulation to members. Firstly, it should be noted that originally public footpath 37 and Whitty Lane ran along the same line between Middle Hume and Upper Hume. During consultation, a full report was sent to all parties. An attached plan showed the claimed upgrade of the whole of public footpath 37. However, in 1997, a small section of the public footpath had been diverted off Whitty Lane around the farmyard and buildings before rejoining Whitty Lane. I noticed an amendment was necessary and sent a fresh plan which ran along the line of the original public footpath 37, Whitty Lane itself, without the diversion. The claimed route runs through the current farmyard and buildings. Before I proceed, I wish to reiterate that all of the evidence and the analysis within the report is based on the amended plan route at Appendix B. This new plan, in turn, resulted in certain sections of the report being updated as per the attached note. The application, therefore, is to upgrade public footpath 37 up to the point at which it is diverted off the lane. A section should then be added, as the evidence shows the route to go through the farmyard and buildings which have been built over the old line. At the point at which public footpath 37 diversion ends and it rejoins the lane, the application is to again upgrade public footpath 37. Officers do not consider that this changes the intention of the report, which is that the evidence is sufficient to show that the whole of Whitty Lane should have restricted byway rights. The main landowner affected is aware of the route through his property, which is reflected within his email in the addendum. He is also aware of a potential diversion should members be minded to accept the application. Turning now to the report itself, can I start with confirming that we have not received any representations or objections from the local member? This is an application made under Section 53 of the Wildlife and Countryside Act 1981 for an upgrade to a restricted byway along part of Whitty Lane and for the addition of a restricted byway for part of Whitty Lane. The application is dated 8th of June 2019 and was made by Louise Redfern on behalf of the Staffordshire Moorlands Bridleway Group. The applicant's evidence included Finance Act maps 1910 and a copy of an email from the British Library dated 7th of October 2008, an extract of the Finance Act map with Whitty Lane highlighted in yellow. The evidence also included a covering letter from a rights-of-way officer for Staffordshire Moorlands Bridleway Group dated 8th of June 2019. In the early 2000s, an application was made to Staffordshire County Council to have the route added to the Section 36 list under the Highways Act 1980. The application appears to have sought the route to be recognised as an ancient highway with ancient highway status, which would provide carriageway rights. The Section 36 list provides that a highway is publicly maintainable either if it was a highway which existed before the 31st of August 1835, or it became a highway after that date and has at some time been maintained by the inhabitants at large at the public expense. This list, however, does not record public rights-of-way, simply whether the route is publicly maintainable. Public footpath 37, which follows the same line for most of it, as Whitty Lane, is currently maintainable at public expense as a public footpath. In the course of the Section 36 application, much documentation was collated from various sources, and this evidence was used to assist the current Section 53 application. This paperwork included Finance Act maps, an enclosure plan of Leek of 1811, Turnpike Road plans, the parish survey card, plan and statement, an ordnance survey drawing and plans, county maps, and also handover schedules and other maps. Following receipt of the Section 53 Wildlife and Countryside Act application in July 2019, an initial consultation of landowners and other parties with an interest of the claimed route was undertaken. This resulted in 2 landowner evidence forms having been received by the council, both of whom consider that route is a public footpath. Landowner 2 additionally stated that the lane serves as a route between 2 farms. The chairman of Leekfrith Parish Council contacted officers with an email dated the 29th of August 2019. The parish provided 6 conclusions explaining why it wished to absolutely and unanimously oppose the proposal. These concerns focused on safety issues, and although these are legitimate issues, they have to be disregarded under the law as it currently stands. A representative of the Byways and Bridleways Trust contacted officers by email on the 25th of November 2019, stating that he believed Whitty Lane to be an old cart road which carried public vehicular rights as well as bridleway rights. He did not, however, object to the application. An email dated 20th of July 2019 was received from a representative of the Commons, Open Spaces and Footpaths Preservation Society supporting the claim. They did not, however, provide any evidence. Using the evidence provided by the applicant and that collated from the landowner and others during the initial investigation, a report was subsequently drafted. This completed report was sent out for initial consultation on the 12th of July 2024. Following the sending out of the report to all parties, officers became aware of an inaccuracy of the plan within the report. Councillors should have received a note circulated prior to panel referring to this oversight. As a result of the inaccuracy, a revised plan was sent out to all parties on the 10th of September 2024, showing the line of route in accordance with the application and the evidence contained within the report. Further evidence was received from Julie Turner on behalf of Staffordshire Moorlands Bridleway Group, which includes the applicant's statement and other documentation, much of which comprised evidence which was considered during the Section 36 investigation. In addition, she also included a paper regarding RUPs and their historical context, and a previous planning inspectorate appeal decision from 2016 regarding a different route. The Council subsequently received emails from an interested party in which this party raised comments and concerns regarding the past and present history of the route. These matters have been responded to within the addendum. Landowner 1 also sent in an objection due to the practical concerns of the claimed rights running through his farmyard. In this matter, there are 2 legal tests which must be satisfied before a modification order can be made for the route. The tests being whether a reasonable allegation can be made regarding the section of the report plan between points B to C that a restricted byway subsists, and that between points A to B and C to D that on the balance of probabilities the higher route subsists. It is your officer's opinion that the application for the upgrade between points A to B on the plan attached passes the balance of probability test, that the route between points B and C passes both the reasonable allegation and balance of probability test, and that point C to D passes the balance of probability test under section 53(3)(c)(2) of the Wildlife and Countryside Act 1981. The clarification note does not make a material difference to the report, which is clear on intention and what you need to consider. Should councillors agree that there is sufficient evidence to upgrade the current footpath rights and to add a section of route along Whitty Lane, they will need to agree to the recommendation listed within the circulated note, and the minutes will need to reflect this recommendation. Thank you, Mr. Chair, and I am happy to take any questions.
Thank you very much. Again, just to reiterate, what did the parish council say about this? Because I'm always a bit nervous about upgrading.
The parish council were concerned on matters of safety, unfortunately, and therefore we couldn't take those into consideration.
Yeah, that's not something that this committee can take account of.
Unfortunately not, no.
Because of the rules. Anyone want to speak on this? David?
Of information. I'd be awfully grateful if you could just reiterate. Are we saying that, as at this moment, and I'm going back to your very early part of the report, that the footpath goes through a barn? I was only going to say that presumably, if it goes through a barn, the barn must have applied for planning permission. Therefore, did the planning permission not take account of the fact that there was a footpath going through it? And are we looking at the moment to a diversion of the footpath that would take it round that area and take the problem away?
The line originally was along the length of Whitty Lane, and the public footpath was diverted around the buildings once. So I think the planning application must have accepted that there was a route, but rights of way were happy to divert the route around the farmyard and buildings. This new application is based on historical evidence which follows the original line, which was before the farmyard and buildings were there, and therefore we have to go along this original line. Of course, that's going to be impractical, and so it's likely that a diversion will need to be made should officers accept the recommendation. I don't know, does that answer your question?
Say that the diversion that was made, was that officially made through this committee at some stage in the past, in which case presumably the problem would go away?
The diversion was made about 27 years ago, and so it might have come through this committee. I really can't comment on what happened 27 years ago regarding how the decision was made as to accept that the farmyard and buildings should be made and that the diversion should ultimately go round it. I'm afraid I can't sort of comment on that. I'm unaware.
Paul?
Basically, whether that decision was made or not is irrelevant to what's going on with this thing there. This is a separate application. So if we agree with Office's recommendation, which I do, it means then they have got to make a new application for a diversion, which is going to go around it. That one is totally relevant to this, because the new application is for the new highway to be basically to go from a footpath to a restricted bridleway. So even the fact the barn's there, it'll still go through the middle of the barn. It just means that the people who own the barn will have to make a new application, which it'll come back to here, and we can then make the diversion order around the barn and around the property. That's how it's got to work. The from 27 years ago can have no effect on what we're doing today.
Sorry, I understand what you're saying, but surely what was done 27 years ago has to be taken into account in what we're looking at now.
No.
There must be some evidence of what happened 27 years ago. Or
No,
not.
it's
If you
different.
didn't, I do understand
No evidence on
the point that you're making, that it would need a new application to divert the footpath at the end. I just wonder when you start
Basically, David, this is a new application that supersedes all that. Nobody was considering making this application when that diversion took place, and then the barn was built, and now somebody has got the old historic thing and says, well, many years ago the path went this way, the bridle went this way, and of course going back to once the highway was byway, it's got to be put there now. So what you're talking about was never considered, because there was no evidence to say a path here was here then, or there was, but it wasn't in the public domain. Basically, I think I'm right on that, aren't I?
Yes, I think that's correct. It's very difficult to sort of, we haven't got records, I'm afraid, from the sort of 29 years ago. They appear to have been lost as to the reasons as to how and why the diversion occurred. So we just have to sort of go on what evidence we have today. So I don't know whether that answers the question.
Carolyn?
Thank you. David, to put it in simple terms, yes, it would have gone through a legal process then, but it hadn't got this little bit of information when it went through that. So there's the simple. So you were right, but there was that little bit of information missing. I'm happy to second the officer's proposal.
Right, we've got a proposal from Paul that we go along with officer's recommendation. A seconder with Carolyn. All those in favour of going along?
The landowner, that they're told all about how they can go ahead and now make a new application for a diversion, so that people don't have to walk through the bedroom or whatever to do it.
Yes, following panel, we will make them aware of sort of alternative
Thank you.
plans. Yes, okay.
Thank you.
Could you switch your microphone off?
Sorry.
Thank you. Thank you very much for that. Well debated. I'm going to move on to item number 8, which is Wildlife and Countryside Act 1981, and this is an application to upgrade public footpath 0.1702 Heathley to a public bridleway. And I understand Rebecca's taking this one.
I am. Thank you, Chair, and thank you, members. So, as mentioned, this is an application to upgrade public footpath 0.1702 Heathley to a public bridleway. I can confirm that we received no objections or representation from the local member. So this application was submitted by Staffordshire Moorlands Bridleway Group. It is based on historical evidence. The applicant submitted 2 historical documents to support their claim. Firstly, the applicant provided an extract from the Ulston Field Enclosure Award dated 1836. In this case, the section of the award that has been provided specifically sets out carriage and drift roads. Carriage roads were specifically designed to accommodate vehicular traffic such as carriages and carts. They were typically wider and better maintained than other routes to ensure that they could accommodate the width of carriages. The enclosure award specified the exact route, dimensions and maintenance responsibilities for the carriage road. Public carriage roads ensured access for all. The route in question is referred to as Pyclough Road and is recorded in the award as follows. One other carriage and drift road in the said township of Heathy to be called Pyclough Road, of the width of 24 feet, leading out of Leakham Buxton Turnpike Road at the top of Morridge, in a south-eastwardly direction over the north end of Royal Cottage. The award plan clearly shows the route following the same line as public footpath 0.1702 Heathy does today. We can therefore confidently assume that the route in the enclosure award and the public footpath 0.1702 Heathy can be seen to follow the same line. The applicant highlighted that the Ulston Field Enclosure Award states that the road is for the use of all persons whose land adjoin the same or who may require or think proper to have occasion to use the same. If you were to consider this statement alone, you could argue this provides good evidence which infers public status. However, without viewing the full enclosure award, we cannot assume that this would be the case. Your officers attended the County Records Office to view the entire original document. From this, it was possible to see the other routes that were set out and recorded at this time. This included information relating to the widths of the route and their maintenance responsibilities. Upon inspection of the award, it clearly sets out in the preamble the powers of the Commissioner. It states, and further enacted that the said Commissioner should, and they are thereby authorised and empowered to make any public or private roads or highway path or paths to widen any of the present public or private roads or highways. It is important to note that the enclosure states that the Commissioner had the powers to widen any of the public or private roads or highways. After 1801 General Enclosure Act, the Commissioners could only award a public carriage road by setting the route out to a minimum of 30 feet. It is clear that although the Commissioner had the powers to widen Pyclough Road, these powers were not exercised in relation to this route. When we consider the routes described in the enclosure award, we can see that the routes that were under 30 feet wide were not listed under the heading of public carriage roads. The routes that are catalogued in this section are all of 30 feet wide or more. For example, we can see that the Leakham Longlaw Turnpike Road is recorded as a public carriage road and stands at 40 feet wide. At the end of the public carriage road section, it states, and we do hereby direct that the said public carriage roads shall be repaired in the manner as any other public carriage roads and ways. From this we can deduce that the route would be maintained by the parish at public expense, as was with all public routes at this time. We can clearly see that Pyclough Road is not listed in the public carriage road section. This strengthens the argument that the route in question was not considered by the Commissioner at the time to have had the status of public carriage road. Instead, this route was recorded in the carriage and drift road section. When assessing this section, we can see that all of the routes were listed as being less than 30 feet wide. The routes are also recorded as being maintained by the owners and occupiers. The entry for Pyclough Road lists who is responsible for the maintenance of the route. The enclosure states, we do also order and direct that the said 2 roads last mentioned shall be made and hereafter maintained and kept in repair by and at the expense of several owners and occupiers for the time being. This statement further strengthens the argument that the carriage road was considered private. Public routes were maintained at the expense of the parish, and this clearly states that the repair and maintenance of Pyclough Road will be at the expense of several owners and occupiers, inferring the route had a private status. So to summarise, the enclosure award did not set out a public bridleway, nor did it refer to a public bridleway. The enclosure award set out a carriage road, and it is clear from the evidence that this was considered private. So now we'll move on to the Ordnance Survey map. And as members know, the OS maps provide good evidence of the physical existence of the route. However, they're silent on matters of status. And this piece of evidence does not help to strengthen the argument that the route had higher rights than that of a public footpath. The route is shown, is clearly highlighted in red, and it shows the route as a well-defined track in the 1895 Ordnance Survey map. So to summarise, the application was made under section 53(2) of the 1981 Act, relying on the event of specific events in 53(3)(c)(2) of the Act. The evidence provided by the applicant does not appear to be strong enough to support the claim that the route has higher rights than that of a footpath. The enclosure award on closer inspection does not list the route in the public carriage road section. Instead, it is listed in the carriage and drift road section. The enclosure award also states that the width of the route is 24 feet wide, which we know would not have been considered wide enough for a public carriage road. The enclosure award clearly states that the landowners and occupiers were responsible for maintaining the route, further strengthening the argument that the route was a private carriage road and not maintained at public expense. The Commissioner also had the powers to create a public carriage road. However, they did not exercise the said powers and chose not to include the route on the list of public carriage roads. The OS map is good evidence to support the physical existence of the route. However, this does not provide any evidence as to the status of the route. So to conclude, in light of the evidence as set out above, it is your officer's opinion that the evidence fails to show, on the balance of probabilities, a public right-of-way with the status of public bridleway which is not shown on the definitive map and statement, subsists. It is the opinion of your officers that the County Council should not make a modification order to upgrade footpath 0.1702 Heathy Lee to a public bridleway on the definitive map and statement of public rights of way. Thank you, and I'm happy to take any questions. And I'm just going to have a cough now. I'm sorry.
Thank you very much for the report. Members? David?
Yeah, I think, firstly, thank you very much for what's quite a different report to perhaps some of the other ones that we have. So thank you very much for that. I'd be very happy to propose the officer's recommendation, Chairman.
Thank you. Seconded by Carolyn. All those in favour of going with the officers? Yeah. Thank you, Rebecca. We'll go with your recommendation. So the final item is exclusion of the public. I don't believe there's anything on that agenda. So it's 5 to 11. Can I thank all members and officers for coming along? Paul?
Just while the camera's still on, can I just thank all the officers on behalf of the committee and you as well, Chairman, for a lovely meeting and excellent reports this morning.
Yes. Yeah, no one can say that we aren't pushing against the traces, to use an agricultural expression. Thank you very much. Thank you all.